have focused intervention, which, as I said, will help kickstart the debate. But to get us all started, I think we've been discussing that Arthur will introduce the themes of his work, the idea of his work, and maybe also what he, perhaps feel free to say what you hope to get out of this day of discussion, so that we all have an idea of what you have in mind with this.
Okay, so my original training was as a philosopher, and then my first year of teaching at the University of Toronto, I was invited to a law and philosophy discussion group and came across some torts cases, and it seemed to me to be that kind of issue that a well-trained philosopher with a couple of hours to spare could just sort out. And, a year or so later, I had a couple of hours to spare, and so here I sit. I became increasingly interested in Kant as a way of working through issues in legal philosophy. And what I want to do right now, by way of kind of overview, is give you a sense of the way in which Kant thinks about the nature of a legal problem, and then turn to the particular question of the nature of law. Because Kant's basic thought in thinking about legal philosophy is that its subject matter is the possibility of freedom, how it is that free beings can interact with each other in a way that is consistent with everyone's freedom. Kant also thinks that in asking this question, one is not only bound to also ask a further question, but one is inevitably already asking a further question, which is the question about the legitimate occasions of the use of force. And so Kant thinks that the possibility of a system in which everyone is free is just the possibility of a system in which there are appropriate reciprocal limits on the use of force. So Kant works this idea up through the categories of Roman private law, which he tweaks a little bit to get them to better fit his way of framing the issue. But the basic thought is that in order for people to interact as free beings, we need to have a law of persons governing the way in which we interact with each other, and a law of things governing property, which then also requires that there be a law of contract, a law of, broadly speaking, fiduciary relations, and so on. And Kant's thought is that these ideas of interpersonal interaction, although we can understand all of them in abstraction from legal and political institutions, we can't actually ever instantiate them except through legal and political institutions. So one of his organizing ideas is that the morality of interpersonal interaction is fundamentally incomplete in the absence of legal and political institutions, as a number of views about ways of explaining what in particular is required, and that I won't go into in very much detail. But the basic thought is that the idea that free beings could interact in a way that's consistent with the freedom of everyone requires that there be limits on unilateral action. I can't bind you in a way that you can't bind me, but Kant will claim that means that, first of all, we need a public system of laws and institutions for making laws. We need public courts to resolve disputes, because I can't unilaterally compel you to submit to my judgment if we disagree about something. And we need a public form of enforcement. I can't unilaterally enforce my rights. Even though Kant sees these ideas of freedom and enforcement as deeply bound with each other, he thinks that the only way you can have a consistent system of enforcement is if we have not private enforcement but public enforcement. But if that's true, then we need a public enforcer not only to have consistent enforcement, but to have consistent freedom. He makes parallel arguments about the determination of laws and also about the creation of powers. Now, I mention all of this, which is obviously I'm putting it in a very compressed way, because this gets us to the distinctive way in which Kant thinks about the state. He thinks about a legal order as something that is essentially public. And this contrasts in ways that I'm sure Annabelle will set me straight soon enough, with ways in which legal orders have been thought of, at least in relation to each other, at other points in the history of legal and political thought. And so Kant is a severe critic of the patrimonial state, that at least according to him, and according to many kind of official histories, figures centrally in writers like Grotius, Pufendorf, and Vattel, the idea that the state is in some sense a private thing standing in private relations to others. But Kant is also very critical of a very different way of thinking about legal ordering, the view that he sees in the natural law tradition, in particular in the school of Salamanca, the idea that in some sense the point of a legal order is to do justice, where doing that is something that you have someone at the apex of it who is in charge of doing it, but really justice is already complete, more or less, in the absence of those institutions. Now, the Kantian view sees states as distinctively public things, charged with making, enforcing, and applying law on behalf of those who are subject to their rule. This then raises a question: what happens when, as is the case in the world in which we find ourselves, there are a plurality of separate states? And Kant's answer is that we have to think of states in a way that is broadly analogous to the way in which we think of natural persons, but not exactly analogous. Kant has particular views that come out of his more general philosophical orientation about the nature of an analogy. Some people think that an analogy is a matter of showing that one thing is like another. Kant's view is that an analogy shows that one relation is like another relation. And so in saying, as many of the classic writers in international law do, that we can think of states as standing in relation to each other in the way in which individuals stand in relation to each other, think of them as moral persons, as the standard idiom puts it. Kant is not saying that states are like persons. He is saying that relations between states are like relations between persons. This is very important because if you think of it in terms of the relations, then you will have a way of understanding the characteristic claims they have against each other, the characteristic wrongs that would violate those claims, without thereby supposing that a state is, in any interesting sense, an individual human being writ large. And so we don't need to suppose that a state is free in the way in which an individual human being is free. We don't need to suppose that states have duties of virtue in the way in which individual human beings have duties of virtue. The question that animates the analogy is the question of how states stand in relation to each other. So that brings me to the official topic of my book manuscript, and in particular to the official topic for today's discussions. That is, how do we think about how things stand between individuals and, between states? And the answer has to be that that question must be answered at two different levels, just as the question about individual human beings must be answered at two different levels. The first level is how things stand inter se between any one state and any other state. And here Kant's claim is that if we think of states as public legal orders, and we think of them as providing a legal order for those who live within their jurisdiction, then we must also think of them in relation to each other as entitled to be independent of the other. Independent in the sense of none being the superior and none being the subordinate of any other. So notice this is a deeply relational conception of independence and a deeply relational conception of the sense in which states are juridical equals. Because of course states are unequal in all kinds of ways, just as individual human beings might differ in their abilities, their strength, their bargaining power, and so on. The sense in which states are understood as juridical equals for Kant is just that none is the superior and none the subordinate of another. That in turn gives each of them an entitlement, Kant supposes, to political independence, that is, that none be dependent on the choice of another, and to territorial integrity, because the territory is just where the state exists as a legal system. Its territory is the place where it exercises jurisdiction. In classical discussions of the relation between a state and its territory, there are two metaphors that compete with each other, one of which says that a state's territory is like its property, the other of which says that the state's territory is like its body. Kant comes closer to the body view, but he wants to reject all of those kinds of comparisons. The state's territory is where it exercises jurisdiction. Its territory is purely a legal idea. So if we think of states in this legal way, Kant thinks that this gives us a distinctive way of understanding the relations between them, and in particular, understanding what the problem of war is, and understanding more significantly why it is that the basic norm governing war can't be what international law used to say that it was, which is if you have a grievance against someone, you demand satisfaction, and if you don't receive it, you're entitled to go to war, or as Pavlakos puts it, put your dispute to the arbitrament of Mars. Instead, Kant supposes that the structure of states understood as entitled to political independence and territorial integrity leads us to the conclusion that war is wrong as such. It's wrong as such because people can't enjoy their freedom except within a legal order. What does a legal order do? A legal order creates a situation in which it's possible for disputes between human beings to be resolved on their merits. We need a legal order to be able to do that. Otherwise, the only way in which any dispute is resolved is through force. But if you think about how things stand between separate legal orders, the problem of war is the distinctive situation in which disputes are resolved by force. Again, if you think about the metaphor of the dice of Mars, as Pavlakos uses it, essentially what you're doing is you're saying there is a dispute and it will be decided through force. Although people go to war because they suppose themselves to have claims, nobody seriously believes that the result of the war depends on who was in the right. You read things from earlier centuries, and there is some evidence that people actually did believe things like that. Dante in his Monarchia actually said that the reason that the Romans won all of their wars was that God wanted them to win. And certainly if you read the Hebrew Bible, there are descriptions of battles where it seems clear that the assumption is they won because God was on their side. And through the 20th century, both sides in every war had their troops blessed by relevant clergy and so on. But when defeated in war, nobody said, oh, we were wrong, we must have been wrong because the other side overpowered us. Instead, we can't seem to think that force and right are aligned in this way. But if the problem of war is the misalignment of force and right, the problem of war is that war is the condition in which might makes right, which is to say that there could be no such condition, then war is wrongful as such. Kant thinks that this leads to the conclusion that the only legitimate occasion of war is national defense. We can imagine situations in which two contending nations find themselves each having reasonable grounds to believe that the other is about to attack. But Kant's point is that national defense is the only possible ground of war. One way of thinking about this point is to say that war has a distinctive morality governing it because of war's distinctive immorality. As the condition in which might makes right, the only way we can understand conduct within war as rightful is as it being conduct that is directed by the idea of peace. Later in the manuscript, I developed Kant's argument that the basic rules governing the use of force within war, use in bello, are all to be traced to this priority of peace. So Kant, like most people before his time, thinks that the basic in bello norm is not non-combatant immunity, but is rather the prohibition of perfidy, false negotiation, or false surrender. And all of the people who Kant criticizes in earlier writings about war all agreed that this was a fundamental wrong, that you can't reach the faith in wartime. Kant has a distinctive explanation of this. Kant thinks that the problem with perfidy is that by its very nature, it makes peace impossible. What the person who uses the flag of truce as a weapon of war does is basically leave only force in place. If you use the flag of truce as a weapon of war, what you've done is you have deprived yourself and your opponent of any possible way out of war. But it's not just that there's no way out, it's that there's no way out of the fact that there's no way out. But Kant doesn't think that this is an empirical fact, that people won't trust each other. Kant thinks that this is a formal structure of practical reason. One way of seeing this, just to very quickly give one of the more detailed arguments, is that it's not just that, as it turns out, abusing the flag of truce will make it harder to reach an agreement. We can see this if we consider the case in which someone successfully engages in a false negotiation or a false surrender and kills all of the witnesses. If we think that the problem of the abuse of the flag of truce is that it makes peace less likely, then we would say, oh, well, this is fine, this is not an objectionable abuse of it. But not only do we think probably that this is not merely not an objectionable use, but in a way it's the most objectionable use, but we can bring this into focus by thinking about the situation of the whistleblower, the person who reveals that this has been done. In terms of the likelihood of a future peace, the whistleblower makes it less likely because he says, look what happened, you can't trust these people. But from the standpoint of the morality governing the use of force, it seems like the whistleblower does the right thing and that the people who engaged in this successful act of perfidy did the wrong thing. So Kant thinks that this is the way in which we can understand the distinctive wrong that is particular to war. Notice that we can also see that this distinctive wrong is not just a special case of the general wrong of deceit. Because if you think about the abuse of the flag of truce, it is consistent with saying that that is wrongful, but what are called ruses of war are perfectly fine. How do they differ? In a ruse of war, the two sides hide from each other their strategies and tactics going forward, but do not hide from each other how things stand as between them. The Allies built a false launching base at Dover just before the invasion of Normandy, so that the Germans would think that the invasion was going to come at Calais rather than going to come at Normandy. In doing that, they were engaged in a ruse. They were hiding from their enemy their plans of attack, but not that they were belligerents. By contrast, abusing the flag of truce is precisely collapsing that distinction, repudiating the difference between peace and war. Kant also has an argument that will perhaps come up later that goes to explain why it is that the protected status of civilians, those who are not part of the war, actually turns on this same idea, the distinction between peace and war. These distinctions don't depend on the ground for which you're fighting, because they are the wrong of false negotiation or false surrender, and the wrong of targeting people who are not part of the war, are wrongs that are internal to the fighting of war. But that means that they are wrongs that can be committed not only by an aggressor, but also by a defender. And that is, the wrong of perfidy is the same wrong on either side. This is true even though we might suppose that the aggressor is not entitled to do anything at all. Nonetheless, the aggressor does a distinctive wrong, a wrong that is proprietary to war by engaging in false surrender or by targeting civilians. The Kantian view also has an account of what happens after war, and it also has an account of the role of international institutions. In talking about war so far, I've talked only about how things stand between the belligerent nations who are at war with each other. Kant thinks that, on analogy with the situation of individuals, nations must exit the condition of force in which they find themselves and enter into a properly public legal order. Kant was an early advocate of a League of Nations. Kant also thought that the purpose of creating such a situation is to have a public forum through which any disputes that arise between nations can be resolved in a way that is consistent with their independence and doesn't depend on the use of force. That is, the point of setting up international legal institutions is to create a system within which there can be no occasion of the use of force. If you think about the rules governing war, the prohibition on wars of aggression, the prohibition on false negotiation or surrender, the prohibition on the targeting of civilians, those rules can move us from a condition of what we might call barbarism to a condition of near anarchy. It's possible for states to get along with to interact with each other without attacking each other if everyone honors those requirements. But we don't yet have a full condition of legality. We get a full condition of legality by exiting the state of nature between nations and setting up global legal institutions, and the book ends with an explanation of why it is that Kant advocates these things, why it is that these institutions have to have powers that no nation has as against any other nation, while at the same time we have to see that the existence of those institutions doesn't create any new rights that any one nation has against any other. I also have, since there's so many international lawyers here, the main response that my work gets from international lawyers is, though less in the last 2 months than it was getting a few months ago, but I gave the Tanner lectures at Berkeley, and Ona Hathaway from Yale was one of my commentators. She said, oh, well, this is all very fine and good, but you have to understand that there are no territorial wars anymore, and nations don't invade each other, wars aren't. And so I never looked at Twitter before, but I decided about 3 weeks ago to start following Ona's Twitter feed. And sure enough, there it is. Territorial war, violation of political independence, territorial integrity, and so on. Nonetheless, there's this challenge. Well, what about all of these new kinds of wars? How are we to conceptualize them, given that even if, as one might hope, the type of war that I am describing has become obsolete? At the beginning of Slaughterhouse-Five, Kurt Vonnegut says that writing an anti-war novel is about as useful as writing an anti-glacier novel. in the 50 years since he wrote it. Glaciers have disappeared, and so we still may hope for the disappearance of war. But it hasn't disappeared, and it has taken these new forms. And what I argue in the book is that although these new forms pose all kinds of challenges in thinking through the application of these category-based arguments, nonetheless, the fundamental distinctions that they draw are the same. And I want to close with just one example of that. As everyone knows, one of the legal innovations, or attempted legal innovations, of the so-called War on Terror is the attempt to replace the binary distinction that was drawn by the Geneva Conventions and that Kant draws on, and was already drawn sharply by Vattel, between civilians and combatants, with a three-part distinction involving combatants, civilians, and unlawful combatants. And you get all kinds of different arguments in favor of this. One is an argument that is, well, it's unfair if people who do not wear uniforms only count as combatants while they're carrying their weapons openly. This is what's sometimes called the merry-go-round argument, that you could turn yourself into a civilian by hiding your weapon. And so this is kind of an argument that says, oh, we need to have a level playing field. To which the appropriate response has to be, well, no, actually, the rules of war are not about having a level playing field. The point of war is not to have a fair contest. If that were true, then we would have to limit the size of the armed forces on each side of the battle. Or we would have to say, oh, you have a new form of armor, you have to give it to the other side too. That's the wrong way to think about it. The other important argument, or influential, I don't know if I want to dignify it with the term important, is that we need this three-part distinction. This argument actually got a lot of traction in the Bush White House in memos drafted by Jack Goldsmith and Curtis Bradley, both of whom have kind of turned into big territorialists and traditional law of war people in the last 5 years. Actually, I think only since Trump was elected. But they basically say, oh, well, what we need to do is have this three-part distinction, because otherwise people will abuse the distinction between combatants and civilians. So we want to have a really, really narrow category of civilians so that it will be possible for people not to abuse that category. This is analogous to the other arguments made in the Bush White House, according to which we should legalize torture because that way we'll have rules governing it. The Kantian view has to say, no, the robustness of these categories can't be vulnerable to questions about whether people are going to disregard them or not. The wrongfulness of battery is not, in private law, is not changed by the fact that, well, if you make battery wrongful all the time, people will commit wrongful batteries. The question of whether it's wrongful or not is a matter of how things stand between the batterer and the person battered. So too, in the case of war, the distinction between those who are and those who are not part of the war is fundamental because it is related to the possibility of a future peace. It's not fundamental because we want to have easy rules for people to follow so that people can have a clear conscience as they indefinitely detain people as illegal combatants by saying, oh, well, we're completely honoring the important thing because these people aren't real civilians. That doesn't mean that there aren't hard questions of classification. There are always hard questions of classification in applying abstract legal categories to particulars. That indeed is one of the reasons, as Kant says, that we need to leave the state of nature and set up a legal order. The point of having a legal order is that we can have officials charged with giving determinate answers to the application of these abstract categories of right to particulars. Finally, George wanted me to say something about what I expect from today. I expect, first of all, I was going to say barrage, but that's just the wrong metaphor here, an onslaught of questions, comments, criticisms. This book is in one way an advanced draft, and in that is I've made up my mind kind of how to think about these things, and in another way very much a work in progress. And so I'm very interested to hear your comments, questions, objections. I don't imagine that I have succeeded in making myself clear on every issue, let alone that I have gotten every issue right, and so I look forward to your comments and questions. Thank you.
Okay, well, great. That's been a great overview. I think it does set the stage. It also is slightly frightening because we all get a sense for how much is there to discuss and how will we manage to do justice to these things. Most of you would have seen this sketchy program, which is sort of our roadmap for the day. If you look at it, you see that George and I and Arthur proposed to sort of break it up into 3 rounds of discussions. Again, no firewalls between them. There's a lunch break between some of them, but it's just our modus operandi for the day. So we propose to start with 3. The discussion sound, the title George and I chose was Normative Foundations, Equal Freedom Beyond the State, which is in some ways the most foundational, perhaps, perspective on the issues. And we propose that there will be 3 people to kickstart the debate, Alain, Tria, and George himself. Now we have just under 1.5 hours for that first round. Again, it's not that everything related to normative foundations has to be said then or shall never be said again. There is flexibility. But this is a way of going about this. So I would propose, or we would propose, that Alain maybe starts, kicks us off, and then if Tria and George have pretty much separate points, then we can have a discussion triggered around that, or based around that, and then we move on to Tria's points and George's points. But the basic point I was making at the outset stands. Let's all discuss. Huh? It's not sort of Alain raising points, Arthur responding, and the rest stays on and listens silently. It's meant to be an interactive discussion, so do jump in. We can start just having this sort of discussion. You just speak when you speak. If this doesn't work, we can draw up a list of sort of speakers if we want a bit more structure and institutions, as it were, to manage it. George and I can provide that. But the point is to have a free-flowing discussion. Okay, so 1.5 hours for this first round of discussion. Arthur, jump in at any point if you feel that people are getting it wrong or you think that... either to respond to questions or to just engage. For others, just sort of speak or signal that you want to speak and we'll call upon you or listen to you anyway. Okay, that's all by way of housekeeping, somewhat sketchy, but I hope it all works out. With that, I think we'll just start with Alain and the first response or first reaction to the points that Arthur presented and the manuscript draft.
All right. Right, so thank you very much, George, for the invitation to try to offer comments. It's a real privilege to try to articulate some comments on this book. I have to say, having read also other pieces of your work, the level of clarity and consistency and ambition that I've found in this book is exemplary, I think, of what we should do. And the kind of work that we should do between lawyers and philosophers. My question basically, I think it basically relates to the genealogy of the book. It has to do with how the Kantian model of the rightful public condition travels across legal fields and legal systems. And I think the underlying question for that would be why you have chosen to focus on the law of war as opposed to other fields of law, of domestic law, or other fields of international law. I think that would be the broad question. And the way I'm going to specify that question will be through this structuring notion of the right to be beyond reproach, which I think really structures, I think, my understanding of your book and of the overall argument. For me, hopefully also for you, the right to be beyond reproach is distinctive of the Kantian approach because, as you very forcefully explain, it goes against this idea of the just war tradition of this sort of unilateral mandate to establish the merits of potentially a just cause, right? And this notion of asserted correctness that you used, that I found very illuminating, I think is the thing that I want to focus on. Why? Because it seems to me that, and that speaks to your introduction about analogy, this basically this usurpation of political authority that is sort of underlying the just war tradition is something that also occupies another field of law, which is the criminal law. So when I understood the structure of this argument, I thought of this debate that we have in the criminal law between, on the one hand, legal moralism, and on the other, what has been called the public law account of the criminal law, which happened to be developed by one of your colleagues at Toronto, Malcolm Thorburn. And I was surprised why you did not draw particularly on that debate. Maybe because there's a fair division of labor between you and Malcolm, that would be a fair argument. But it seems to be that if there's one area of law where basically there is a high risk of this usurpation of political authority, it's the criminal law. So criminal law, according to Thorburn, prohibits us from doing what seems to be the right thing. And that's what we need, legal institutions. Whereas legal moralists, for those that might not be familiar with the debate, legal moralists rather think that we can impose punishment just because people deserve to suffer for their wrongdoings. That was just a thought that I had, because it seems that the debate that you are intervening in at the international level has a very analogous structure in the criminal law. That's the first step of my question. The second step is, if that symmetry, if that level of analogy is correct, then I'm wondering why you go for, to put it straight, why you go for the law of war as opposed, for instance, to international criminal law. So international criminal for me is an even more salient instance of, international crimes are a salient instance of the violation of the rightful public condition, because it's not only that one private individual is attacking me, but institutions themselves that attack a significant portion of civilians. So I thought that if we were to start with the domestic level and try to find the most salient instances where the Kantian account could be powerful, it would be international criminal law and not the law of war. So I totally see that the Kantian account applies equally to the law of war and to international criminal. I'm sure with some specification, but I think that the right to be beyond reproach applies equally at the level of principle, at least. And so I just wonder why you're not going for international criminal law. This is just me and myself trying to think about that. And one last thing, for why there could be a reason, why you could also apply the Kantian account to international criminal, is that your argument against revisionists in the just war debate applies equally to international criminal law. So revisionists think that, as you explain, no new moral principles are introduced by the fact that wars are fought between larger units. Well, people think exactly the same about international crimes. Some people think that international crimes are not particular, they're not distinctive, because they involve the perversion of political authority. International crimes simply have to do with the level of gravity of attack upon individuals. So of course it seems to me that the Kantian account would have something very interesting and distinctive to say about international crimes, the way they are structured. So again, I see high levels of analogies between the generic Kantian account and how it could straightforwardly applied to other fields of international. So that sort of supports my question of why you go for the law of war. And then, just to conclude, then of course I read that sentence that I think is also very illuminating. You say that according to Kant, the normative principle that applies to a thing can only be understood in relation to the ideal or proper operation of that thing. So if that applies, then it seems to me that it's just up to us to measure the scope that there is between that ideal principle and the current situation, the current standing of the law. And so we could do that in relation, of course, to constitutional and human rights law. We could do that for criminal law and international, the criminal law, domestically, international criminal law. I'm lost about the criteria why we should go for one and not the other, and why you should go for, and why you've worked so much on the law of war. Thank you very much.
Thank you. So, even though we're supposed to have everyone jump in right away and see everyone's sitting on their hands, so let me just say something very briefly to Alain's very helpful comments. So, one answer to why I'm working on it is that I gave a talk once and someone in the audience said that, asked me, well, how would that apply to such and such? And so again, I kind of thought, oh, well, so I'll just kind of write and add a paragraph to this paper about some other topic, and then I will have answered that, and that was 9 years ago. So that's one answer. The other answer is that there is this so-called revisionist movement in just war theory that seems to me to be completely oblivious to, well, Michael Walzer, who is the target of many of their attacks, once facetiously commented that they all think of war as a peacetime activity. That is, that it misses out on the distinctiveness of war, and so given that Kant ends the doctrine of right with the claim that practical reason has an irresistible veto, there shall be no war, that seemed like a good place to start. But more than that, the case of international criminal law, as you mentioned it, I think it's a very interesting case, and it's too bad due to international labor disputes, if not international labor law. Klaus Kresk was unable to be here today because, of course, that's exactly what he works on, and he drafted the crime of aggression statute for the Rome court. But my thought is that that kind of question can really only be understood within the context of a question about war. Historically, I guess that the earliest origins of international criminal law are probably the prohibition on piracy, because the pirate was the common enemy of all mankind. And one of the things that was interesting about the law of piracy is, on my limited understanding of it, the pirate could be tried by any nation, but it was always the nation whose rule of law the pirate had attacked. And so there was a way in which the pirate was the person who sought to stand in a state of nature in relation to any other nation. And of course, as the workaround for this problem, that the nations of Europe developed letters of marque in the category of privateer, who was in some sense a pirate working within the limits of the law, and suddenly there was no international criminal law. That turned it into either allowable action, but normally that just made it part of war instead. International criminal law has really come into its own since the Nuremberg tribunals, and it seems to me that the only way that we can properly understand it from a Kantian point of view is by understanding it as something that has to be an act of the international legal order and not of any particular nation. And so you mentioned the difference between the legal moralist and the public law models of criminal law. I think you're right, that debate replays itself in the context of international criminal law, precisely because there are people who say, oh, well, anyone can punish these things because they're bad, and then the question of who gets to punish is treated as a question, well, of, in some sense, strategy and competence understood not in legal terms, but in terms of efficacy. Some things are bad enough that everyone gets to punish them. Other things are less bad. And that seems to me to be the wrong way to think about it. And I think that there's kind of a nice Kantian formulation of why it is the wrong way to think about it, which is that wrongdoing doesn't ordinarily come in degrees. And so murder is murder. Mass murder is, if you think of it in terms of its wrongfulness, it's just multiple cases of the same wrong. And so there's a question about why we would think that was more serious, as opposed to thinking about it in some other way. So the Kantian way to think about crimes against humanity and the crime of aggression, I'm with Philippe Sands on the dispute between whether genocide or the crime of aggression is the, as it were, juridically basic crime. I think crimes against humanity are the juridically basic case. Genocide is a way of committing a crime against humanity. It is, if you like, an aggravating factor rather than a basic case or fundamentally separate case. But the reason that I put it this way is that it seems to me that in cases of crimes against humanity, what you have is something that is not simply a violation of a particular individual human being's right, nor is it the violation of a whole bunch of particular human beings' rights, both of which are obviously terrible things, but rather the thing that is distinctive about it is that a crime against humanity is inconsistent with the possibility of people living on rightful terms at all. So if you think about that, then you see that, and of course the Nuremberg tribunals struggled with this because they predicated crimes against humanity on the crime of aggression. And so the crimes committed by Nazi Germany within its own borders were simply outside that scope. And so we want some way of conceptualizing it such that the wrongs that Nazi Germany committed against those who had been German citizens, of whom they stripped their citizenship, and against those who had never been German citizens, were part of the same crime against humanity. They weren't different kinds of things. And the Kantian thought is that these are wrongs because they are inconsistent with rightful relations as such. And so if you have a systematic genocide, or a systematic killing of some class of persons, however exactly identified, that seems to be inconsistent with rightful relations simply as such. So I am toying with adding a section to, so you asked this other question, which I'm going to pretend was just a kind of strategic question about writing. Should I add a section to my final chapter where I talk about international criminal law? And partly I'm tempted to do so, and partly I'm worried that I am going to be able to only describe it in such schematic terms as to make it not really be illuminating. I thought, well, I could write another book about that, but I need to wait and see whether that happens rather than plan to do it.